A very good afternoon, everyone. Welcome to today's session of the Avid Readers Forum. Before we start, we'd like to have a prayer. Ms. Sylvia Nyanchama, please invite God to our session.
Okay, let us pray. Our gracious and merciful Father in heaven, dear Lord, we're thankful for this day. Thank you for enabling us to have this session. We do invite your spirit that for whatever we're going to discuss, may it bring glory and honor to your name. And dear Lord, may you bless all the participants and panelists in this session. It is my humble prayer in Jesus' name. Amen.
Amen. Thank you for that, Ms. Sylvia. Now, let me introduce this mighty forum for those of us who may not be familiar. The Avid Readers Forum is a forum for having legal discourse. We occasionally meet to discuss legal developments, legal matters, and anything that's worth discussing. And we began in 2019, and we were founded by the great Mr. Elisha Zebedi Ongoya. And today we are discussing accountability in debt contracts in Kenya. So just to give a brief background of our discussion today, I'd start by defining very simply and very briefly what debt contracts are. They're typically arrangements where a lender agrees to give money to the borrower or their designate, and it's based on terms that the borrower should fulfill. Most of the time, those terms include a condition that the borrower must repay that money with interest. Now, in terms of a country, those terms may include many things. The countries may engage in an exchange program. The lender may require the borrowing country to undertake the development projects or something like that. So as you may know, Kenya has been engaging in many debt contracts for the longest time because we keep borrowing money all the time. However, citizens are not always aware of the terms and conditions of those contracts. And for our discussion today, we are discussing a case that was instituted at the High Court by the Institute for Social Accountability and Ms. Wanjiru Gikonyo. They're arguing that the Cabinet Secretary for National Treasury and Planning should provide information and documents relating to sovereign bonds and other loans, basically debt contracts in Kenya. So that's what we're discussing here today. And without much further ado, I'd like to invite the panelists. Before I do that, let me give you a very, very brief introduction of who they are. So first up, we have Ms. Wanjiru Gikonyo, whom I've mentioned before, and I've noted that she is a petitioner of the case that we are discussing today. Next, we will have, she's also the founder of this Institute for Social Accountability, and you have seen her around everywhere. She's a public-spirited citizen, and she's a very active litigant. She tries her best to keep the government in check any opportunity she gets. Then we have Mr. Evans Ogada, who's a legal practitioner and an adjunct lecturer at the University of Nairobi. Mr. Ogada has some insights that you may want to stay to listen to. For those of you who know, he's a pretty well-spoken guy, well-read, and he knows what he's doing. Then we have Ms. Diana Gichengo, who is the National Coordinator of the Institute for Social Accountability. Ms. Diana Gichengo is also a legal mind who has been in the game for quite a while, and she has mastered her craft, and she's very suitable for this discussion. I'd also like to pass my apologies from Mr. Washira Maina, who was supposed to join us today, but he has an emergency, and so he will not make it to join us. But rest assured, we will have a very fruitful and engaging discussion. Now, let's kick off with Ms. Wanjiru Gikonyo. Ms. Gikonyo, if you could please talk to us about the background of this case. Why do you want to know about the debt contracts that Kenya is signing, and why did you decide to take this matter to court? Over to you, Ms. Gikonya.
Thank you very much, Marion, and thank you too to the Avid Readers platform for this very important space that you've created to help us share and learn about legal developments. This case was instituted in conjunction. In fact, the first litigant is the Kenya Human Rights Commission, and then TISA and myself on behalf of TISA came into the case. And we did this as we were tracking the ballooning debt in Kenya. And if you recall, 2021, 2022, as we were moving towards the elections, the impact of debt was also a center stage conversation. At this point, Kenya had entered into the IMF fiscal consolidation program, and we were hoping to get some 2.3 billion USD to help Kenya in the resurgence of growth, shared prosperity, reducing debt vulnerability, structural reforms, other noble objectives. But against that backdrop, we were hearing from Parliament that they did not have adequate debt information. This was coming from APNAC, which is the committee that looks at looks at corruption and is set to fight corruption. And we had recognized that the procurement of debt was being driven by budgeted corruption. And so the inability to get the contracts meant we wouldn't know the true amount of debt, the true purpose of the debt, the hidden commitments, such as the collateral that had been offered for that debt, the penalties that would come with that debt. And also we wouldn't know who was really behind these contracts, the beneficial ownership arrangements, because we wanted to stay away from predatory lenders. So in public interest and to fight against budgeted corruption, we felt it's important for us to have an omnibus kind of public interest litigation asking for the contracts, because there were other specific public interest suits. We had one on SGR headed by Muhuri and Helef Khalifa. We had also, there's also other, legal cases that had been filed around specific provisions. This one seeks to get all the contracts in line with public finance management requirements, so that we can get these details that are necessary to be able to ensure our money is well spent, and where it hasn't been well spent, to know who to hold accountable for what then becomes odious debt. Marion, I think I'll stop there. Thank you.
Thank you very much. That was quite succinct, short and sweet, as in, if you may. Next, we'll love to go to Mr. Evans Ogada. Before we do that, I'd like to remind our audience that you can type in your questions and comments. There's a section for that, so utilize it. We are here for you, so let us be here for you. Mr. Ogada, you happen to be the petitioner's counsel, but also you happen to be a legal mind. So tell us, what are the legal underpinnings of this case? And what is the law regulating debt contracts and their transparency in Kenya? Welcome.
Good afternoon, Marion, and good afternoon to my friends at Kabarak. May I express my utmost gratitude to the leadership of Kabarak University, to the leadership of Kabarak Law School, led by the very eminent Professor John Mbani, faculty members, Mwalimu Sipala and the rest. It's good to be here. Thank you very much. Now, James Madison, America's fourth president, said that a popular government without popular information or the means of acquiring it is just but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance. Madison continues to say that a people who mean to be their own governors must arm themselves with the power knowledge gives. The listeners, there is a conceptual and a philosophical shift under the Constitution, with the emphasis on the term governance, departing from what we had under the old order as government. Governance means you have to incorporate the citizens as partners. Citizens have to be active in the management of their affairs. And in managing their affairs, these citizens have to have information so that they meaningfully contribute to matters governance. Marion and those who are students of history, you will understand that the term government draws from the Latin term gubernare. Gubernare means to steer. You cannot steer a population that does not know the direction, that cannot chart their own future. Now, what are the legal and constitutional underpinnings of the petition, as you asked, Marion? We have to start with the preamble to the Constitution, and the preamble lays a moral foundation on the issue of good governance. The preamble spells out the aspirations of Kenyans for a government that should be based on the values of human rights, freedom, democracy, equality, justice, and the rule of law. We also have the concept of sovereignty at Article 1. And Article 1 states that all power reposits in the people, and that authority exercised under the Constitution must be in accordance to the Constitution being the articulated blueprint of governance. Notice that I use the term power when referring to the people and authority when referring to the governors. It's not idle, Marion. Power is unchecked. Power is unbridled, and that belongs to the people. Any other person who exercises power in a delegated sense from the people has to know that you are exercising authority, and that authority has to be circumscribed. That's a whole lesson in constitutional law on Article 1. Then we have Article 2, the supremacy clause. It basically states that the Constitution overrides and preponderates all else, meaning that you cannot claim to exercise governance, and not hearken to what the Constitution says. So you have to respect the authority and what the Constitution says. Article 3, and that is why the petitioners are in court. Each and every one of us has the obligation to protect and preserve this Constitution. Article 10. Article 10 gives us a semblance of certain constitutional values and or principles. We have other principles and or values within the Constitution, but the starting point, we start with the meta principles at Article 10. Now, these principles are architectonic, they are foundational, that every other thing, every other aspect of the Kenyan state must be predicated, must be founded on constitutional principles and certainly on Article 10. Then we have Chapter 6. What others, including Mwalimu, my teacher and good friend Elisha Ngoya, have asked whether this is the dead chapter of the Constitution. Chapter 6 was to be the moral part of the Constitution. That when you are exercising or steering the reins of public office, you have to make objective decisions. You have to be accountable, and you have to avoid situations of conflict of interest. That is the essence of Chapter 6 of the Constitution, and certainly you read Article 73, 73 to Article 75, you glean the fine enumerated articulations of constitutional morality. Then we have Article 201, the principles of public finance. At Article 201, it is declared and decreed that we shall operate systems of public finance of the Kenyan state according to principles of openness and accountability, so that you have to be accountable, you have to be open in all aspects of the Kenyan financial system. Then, of course, we'll have Article 225, and Article 225 brought a question. Marion, you and those of you who are researching for constitutional law questions, I want you to ask yourself, why is it that Article 225 introduces the National Treasury? In other constitutional context, Article 225 may be argued to be an establishment clause. So, being an establishment clause, what does it mean when the Constitution at 225 says there will be an established national treasury? What does that mean in terms of its functional and normative importance? Then in terms of, we have the Access to Information Act, which is a normative derivative of Article 35. You will look at Section 4 and Section 5 of that Act, which places passive and active components in terms of access to information. Now, the history leading to this petition was that the petitioners wrote to the then CS for Treasury, Mr. Okori Etani, on the 7th of February 2022 through their counsel. And the petitioners, as my good friend Njiro Gikonyo has said, sought a number of questions on those parameters I have enumerated, the constitutional and legal parameters. The CS Treasury gave us what I call a water lily. He fobbed off some of those questions. He was not candid enough, and hence the reason why the petitioners are in court. The matter has been heard. We are waiting for the decision of the court in due course. I think it will be sometime in the month of September. Thank you very much.
Thank you, Mr. Evans Ogada. As a student of constitutional law and history, I have thoroughly enjoyed your presentation, and I'm asking myself the questions that you have noted that we should ask ourselves as students of history and constitutional law. I hope to find answers eventually, but for now, I'd like to invite Miss Diana Gichengo, who right now she's in this Institute for Social Accountability But at the time of instituting this case, she was in the Kenya Human Rights Commission, and she has a huge record in the human rights field. So we were just wondering, Ms. Gikonya, what's the relation between debt contracts and human rights? If you could address us on that. Welcome.
Thank you very much, Marion. And yes, at the time of instituting this, I was at the Kenya Human Rights Commission and more in the human rights space. But to be honest, maybe back then I did not understand significantly the impacts of why we should care about public debt accountability and the impacts on human rights. We definitely were part of the Okoa Uchumi coalition. But now I am on this other side, maybe I have clarity of both. And having heard from Wanjiro, who then is the petitioner, and Ogada, who leads us in a lot of the litigation we do around fiscal constitutionalism. First, allow me to indicate that over the years, and I like to create this analogy whenever you're discussing human rights and you're given the implication that the duty to promote, protect, and enforce largely falls with the state. The imagery you create of a state is, say, the department or the Ministry of Interior and coordination of national government. If we are suing around human rights, human rights violation, we will mainly go for, most of the litigation in this country has been the CS Interior, Office of the President. We are not even very good at litigating on enforcement of, say, socioeconomic rights. There has been a bit of litigation on housing. That's when maybe you will go to the AG, but still Interior will rank somewhere there. So that imagery of the state being the security operators and so on was well fixated in my mind, and I engaged the Ministry of Interior in a lot of the work around human rights violation. And they embody the state in a certain way. But to be honest, when then I started working on issues of economic justice, debt, public finance management, and accountability, I'd like to say the state is Treasury. It is a Ministry of Finance. You will not be able to promote, protect, and enforce any human rights if there is no resourcing for it. If we want to protect the right to life, it means right from birth, there has to be proper maternal care, go all the way. If there is a crisis, security operators, intelligence gathering must be spot on for us to lead a healthy life, socioeconomic rights, all that is budget. Now, public debt, unfortunately, and most of sovereign debt, we see it as just ordinary borrowing. It is not. It is always repaid using taxpayers' money, which is the same, borrows from the same kitty that ought to be utilized for enforcement and realization of human rights. But because public debt is deferred taxation, the higher it gets, then the more it takes away from human rights, protection, obligation, enforcement, and fulfillment. Based on this, and I don't think I would need to belabor, we've done, say, an analysis that shows for the health department, we are on a decline. We had gotten during COVID to a point where we would have as high as 7% of the budget being allocated to health at national and at national and county government level. Right now, we've gone down to 3%. What is a result of this? It's the fact that most of our county hospitals, the referral hospitals, you're getting the very basic services and goods. it means we are nobody is willing to cooperate with us in ensuring that we have the required medication. You saw what happened with the doctors' strike and the interns. That has a direct correlation with human rights. We are students. We are among scholars, legal scholars in university. When the budget shrinks because we have very high debt servicing commitments and requirements, immediately we slash. And unfortunately, because of how much taxation is based on representation, cuts go to areas where they cut on huge numbers. That is why the government will never speak about, say, cuts to things that do not affect the masses. Foreign services, no, that is not everybody. They will go to education, health, agriculture, where it is huge. The same way, when they want to increase their revenue, they will go to the areas that will attract the highest possible numbers. So we get huge budget cuts in the education sector. We are not able to resource our primary and secondary school education. We go in there and we affect not just the right to education, it's the fundamental freedoms of a child. To basic food and nutrition when they are accessing basic education by attempting to slash, say, the free feeding program in day primary schools. University, the full realization of what you can achieve when it comes to education in this country is now being affected by the new funding model. All these are the impacts of debt. And when we think about accountability for public debt, therefore, we must rope in, like we've done in this particular litigation, Treasury, which leads in that particular commitment. But we must also, based on our constitutional architecture, direct the bulk of our attention to Parliament, which ultimately makes or is the one that gives the nod for the commitment around public debt, because they're the carriers of the public purse. At any given point, they ought to know. And I think it's Article 211 that lately I like to refer to whenever I speak to parliamentarians who say that they are not able to access any debt information at any given point. And the discussion here, if you read it, because of where the Parliament is placed in our constitution, Parliament has the power to prescribe terms on which the national government may borrow, impose reporting requirements, and 211 sub-article 2 says within 7 days after either House of Parliament so requests by resolution, the Cabinet Secretary responsible for finance shall present to the relevant committee information concerning any particular loan or guarantee. And it covers anything you would require, everything Shiro stated. What are the terms of the contract? What are the conditions therein? What are the terms of repayment? What are the indirect and hidden clauses? Within 7 days. So if there's an institution that has failed Kenyans consistently, yet they have all the constitutional mandate, is Parliament. And there are all these excuses that are given, international sovereignty, diplomacy, what? I would go back to the universality of human rights. And if that is affecting us, our constitution in Kenya remains supreme. Globally, and when we go to enforcing human rights for their universality, then people who are entering into contracts that jeopardize the human rights of Kenyans must be accountable. And luckily, even within the trade space, the United Nations Conference on Trade and Development, they have a principle on responsible sovereign lending and borrowing that requires the lender must ensure that whatever contract they enter into with a state, one is authorized. So there's a whole process of how we authorize our public debt in Kenya. Then secondly, is it enforceable? So whenever we are given excuses of, oh, it is national security, oh, our diplomatic relations, I think both within our constitution and within international law and emerging norms, clearly the place of accountability and the very high level duty of care when it comes to sovereign borrowing and lending just circles back to where Kenyans, scholars like yourselves and Gen Z have taken us: accountability, because if we don't do that, then our human rights will become not a mirage, they'll just be tramped on and buried. I'll pause there for now.
Thank you so much, Ms. Gishengo, for that reminder that everything is tied to money, and without money and accountability, especially with public funds, we'll have problems in every sector, quite literally. Thank you for that robust presentation. Now, I'd like to open the floor for questions, answers, comments. Our dear audience, this is your chance to interact with the panelists. So type in your questions. Those who want to speak, you can raise your hand and then we'd give you the permission to speak.
Marion?
Yes.
If I may,
yes, you may.
There was a point I wanted to touch on.
Yes.
Just very briefly, as Councillor Ogada was speaking, it came to me, and even Diana has, I think, brought out really powerfully the impacts of debt. We are, and I'll go back to this fiscal consolidation program, and I will also reiterate that the problem we have with debt management is a political problem, and it's the political problem of budgeted corruption. And this is something that since 2013 has really come to bear. And there's some data that shows in 2009, our borrowing, of course, was much lower, but 60% of everything that we borrowed went into the social sectors, the sectors that Diana has mentioned: health, education, agriculture. By 2020, only 18% of what we were borrowing was going into service, into the social sector. The rest was going into infrastructure. And infrastructure, as we know in this country, is riddled with corruption, inefficiencies, and a lot of cronyism, and is used to finance political ascent into office. It's really around the opacity in the infrastructure sector. Now, this happens against a backdrop. This drew us into an IMF program that has pluses and minuses. And the pluses with the IMF program are that the IMF, over time, we have seen increased transparency in terms of debt reporting. Where we were before we started the program, if you look at the requirements in the Public Finance Management Act of sections 31, 32, 33, 34, in terms of the reports that Treasury was producing, Parliament was producing, there was a lot of missing information. We now have more transparency, but we still had to go to court because Kenya has transparency without accountability. So the government of Kenya, and Treasury in particular, is able to tick boxes in terms of its compliance in the IMF international debt transparency requirements. Are the legal definitions of public debt clear? Yes. Do we have clarity in the definition of debt instruments and the reporting? Are the legal mechanisms in place? We can say, yes, Kenya has a debt management office. Kenya has a medium debt strategy that is published every year. Kenya has debt management reports that again are produced every year. And the level of information is increasing, which is a plus. But the big concern is that the needed information the devil is in the detail in terms of the beneficial ownership, the issues that we are saying. In terms of, and I'll read something that came out of the Auditor General report of 2024, saying the Auditor General was unable to access debt contracts. And in the end, when they were reviewing Kenya's performance on debt, they were only able to get a small sample of what they wanted. What did they find? They found that there was inadequate transparency in the loan contracting process. There were variances in debt figures. There was lack of adherence, which led to incurring of penalties. There was lack of compliance in the feasibility documents. Only 18 out of 32 of the sample that they looked at, audited, had the needed feasibility documents. Lack of compliance in public participation reporting, only 10 of 32. Project appraisals, only 11 out of 32 projects had appraisal documents. Loan negotiation documents, only 2 out of 32 were availed. And in terms of legal opinion and clearance by the Auditor General, only 5 of 32. So the phrase, of course, has become Kenya is a crime scene in several matters. And definitely in debt procurement, it is a crime scene because we have the legal framework. We even can say we have the documents and being generated, but the information that's needed is then missing. And as Diana said, Parliament then is not exercising its oversight by, one, following up on the Auditor General reports that flagged these gaps, to hold the relevant accounting officer accountable, and to ensure, as Diana has said, these documents are then produced as necessary. So matters we've gone to court, and it's so important for us to use public interest litigation, we must recognize this is a political problem. And this is where movements and coalitions such as the Okoa Uchumi are very important. This is why what the Gen Z uprising, the Gen Z revolution, the Gen Z spring is so important, because it's only, we have to assist the courts to make the right judgments by us also engaging in the political space. Yeah, I'd like to stop there. Thank you.
Thank you. Thank you so much for that highlight, Ms. Gikonyo. Now we'd like to move over to the Q&A session. Again, you can raise your hand, you can type in your comments, and as you do that, I'd like to read out a question that we have on Facebook by Okoth Matthews, who's asking about the conflict between confidentiality clauses in international debt contracts and the rule of law requirements for open government. I think I can refer this question to Ms. Gishengo because you have spoken about something similar. There is another question that's asking, can the Constitution of Kenya, a domestic law, be cited in international debt contracts entered into with other sovereigns and multilateral banks to override those contractual debt obligations? I can refer this question to Mr. Evans Ogada, because it's pretty much the Constitution. And there's another question. President Ruto formed a task force on public debt a few months ago. It was found to be unconstitutional. But assuming it was constitutional, would it have made a difference in making debt contracts more accountable to the public? So I can refer this question also to Mr. Ogada. Ms. Gishengo, such short notice, but I hope you're ready to give us an answer to the first question. on whether there is a conflict between confidentiality clauses in international debt contracts and the rule of law requirements for open government. Welcome, Ms. Gishango.
Sorry, one second.
Okay.
Can you hear
okay.
me?
Yes, we can. Yes, we can.
On my camera. This one is I had earlier.
You've muted. Ms. Gishango, you've muted. You muted your device. Okay, we seem to be having challenges with Ms. Gishango there. Mr. Ogada, perhaps you can answer as we wait for Ms. Gishango to come back.
Let me start with that question by my good friend, teacher Matthews, of course, on confidentiality clauses versus the rule of law. The constitutionality clauses, depending on how they are worded, may raise one or two issues, but certainly those do not override the obligations of the Kenyan state that is a party here. In terms of the obligations of the Kenyan state, they have to disclose. And the manner of disclosure, they have to choose because the Access to Information Act gives us leeway, gives the state leeway in terms of what they can disclose. So it's for the Attorney General to guide on what is to be disclosed, and if they feel that certain matters are not sensitive enough, they have to declare to the court and to Parliament why those bits they consider not disclosable are sensitive and what interests they are going to harm. So you don't just come to us in the public and say, we are not going to disclose the entire thing. For example, let's be logical. There are certain contracts dealing with defense and national security that may not warrant full disclosure of certain specifications for security reasons that we understand. But it is not open for the executive to say, this is a blanket non-disclosure requirement for us, we are not going to disclose. It's wrong. Go through the court system, let us go through the full trial, declare what cannot be disclosed in camera, if possible, and let the court adjudicate on those specific items. That is what I will say on the so-called confidentiality clauses. In terms of the Constitution being cited on as against multilateral and bilateral contracts, of course, yes. Because we have a whole chapter, Article 201 to Article 231, Chapter 12 of the Constitution, and Article 201 is our principal provision. It talks of openness. So this money is being borrowed on behalf of the Republic of Kenya. So you cannot tell us that you entered into a contract and this contract cannot be declared and disclosed to the Republic. You will be missing the point because the country, the Constitution requires that you borrow on our behalf, and that borrowing, the components of public finance must be open. So the Constitution should guide the Kenyan state on matters borrowing. So whatever arguments being made out there, the Constitution still reigns supreme.
Thank you for that explanation, Mr. Ogada. Ms. Gishango, I see you're back. Are you able to talk to us?
Marion, I hope you can hear me.
We can hear you. We can't see you, but we can hear you.
Okay, great. Thank you. And luckily, I think Ogada, my senior, has spoken to this particular. I would move away from treating debt contracts as debt contracts. Sovereign debt, unlike any other form of sovereign debt contract, unlike any other form of contract, must whenever it is weighed against the sovereignty of the people under any constitutional democracy, as we've seen in the case of, say, Mozambique. I think there has been a case in the Congo. The African Commission had attempted an earlier case around a resource-based contract, somewhere I think in Nigeria. You cannot hide under confidentiality for something that is to be paid by the public, but it is not yet expressed, and it has been used continually to be a blockade or a barrier to the required transparency and accountability. But I think increasingly, even the principles that are being put forward by the International Financial Institution, the coalition of all supreme audit institutions, the equivalent of our Auditor General, are moving in the space of cooperation to ensure highest possible transparency. And if we are even to borrow from our neighbors, Uganda, and their public finance processes, budgeting processes, they're slightly ahead of us, because for them, debt contracts must be expressly approved by Parliament. So, and I would go back to the same clause that I cited, Article 211 for the Kenyan case. It doesn't create exceptions. So according to our Kenyan constitution, even just a reading of the PFM chapter alone and that clause 211, it doesn't create any exception of what cannot be disclosed to Parliament around any public debt. But definitely, I think to give this the required force or status for the sake of accountability, we may need to either put it expressly in our PFM Act or go the way of ensuring we get strong jurisprudence on this area of fiscal constitutionalism, representation of the people when it comes to public debt. But I would lean more. I don't know, maybe commercial lawyers would have a better case to make. I am more of a human rights lawyer. I don't see how confidentiality would win. Who is this that we are? Whose confidentiality are we safeguarding? Yet this has implication on 15 million citizens for the case of Kenya. So that would be where I stand on this.
Thank you. Thank you for bringing that human rights perspective. We have another question that's directed to Ms. Gikonyo by Sylvia. Sylvia is asking, we have seen the executive over and over again being in contempt of court orders or directives by the judiciary. How then, if the court rules in your favor, are you planning to go about execution? What if the executive just doesn't release the contracts or the information on the same? That's a question by Sylvia. I think I saw a hand up. Caleb. Caleb, proceed. I think you can speak now.
Well, thank you very much for unmuting me. Whenever we have these conversations, I look back and ask myself, what are our existing problems with regard to the debt crisis or a particular crisis? And currently, we are in a debt crisis, such that I think March, either this year or last year, Kenya was unable to pay salaries due to the debt crisis. Will this advocacy, which we are doing here, and this discussion solve our already existing problems with regard to debt? Thank you very much, Marion.
Thank you very much, Sadala. We have another hand, Adeline.
Good afternoon, everyone. I really hope I'm audible. Thank you, Marion, for that. And so far, it's a lovely session. Thank you to our lovely panelists. My kind of question is tied to what Sadala and Sylvia have raised, because I think it's reached a point where there's discussions around it, but in terms of execution and implementation, it's not really there. Because if right now, where is our president? At the moment, our president is in Beijing, and from what I last read, which is like yesterday, there's conversations to build the the Malaba road, something of the sort. And we know that this will also, he might also want to initiate and take debt. So even if we have a court case that is happening at the moment and we're waiting for judgment, how effective are these judgments and conversations if we still have the executive moving around and if they're still continuing to, take this debt? So on top of the debt crisis that we have, we're still continuing to take debts. So mine is just how effective are these judgments and kind of this academic discussions that we normally have. So this is closely tied to what Sadala has asked. Thank you.
Thank you, Adeline. Adeline happens to be the president of Kabarak Law School. So thank you for leading from the front, being in such a panel. I mean, a discussion which is pretty much academic. It is not typical for regular students. So thank you for leading your members. Then we have another question by Jeff. But before Jeff comes in, and I hope Mr. Ogada and Ms. Gikonyo are ready to answer the questions that have been asked by Adeline and Caleb. Then we have Jeff Franklin, GC. Yes, Jeff Franklin, I believe you're able to speak.
Thank you so much. Confirm if you can hear me.
Loud and clear.
From what I've been hearing, the way we've gotten into this, I'd call it a debt trap, is to a great extent due to bad leadership. Is it possible that one day, via, let's say, a unique petition, be able to hold specific individuals to account, like bring them to justice? We say that, had you done your job properly, had you not been grossly negligent, we will not have gotten here. Is this a possibility within our current constitutional framework? Thank you.
Thank you very much, Jeff, for your question. I'll now invite Mr. Ogada to respond to the questions we have so far. Mr. Ogada, I hope you're ready.
Let me start with the last question, the possibility of holding persons to account that was posed by Jeff. Don't be weary. Don't lose hope. Of course, there are determined political and interest forces that are hell-bent at undermining the Constitution. This is not unprecedented, and you will see traces of this in terms of history. Those of you, again, who are students of legal and constitutional history, I want to take you back to around the 1930s, the early 1930s. We have Germany ushering in a new constitution called the Weimar Constitution. Now, the Weimar Constitution was touted as a progressive constitution, a beautiful constitution, quite energetic in terms of its intentions. And that constitution was intended to change Germany and to modernize German prospects. However, there were those who were hell-bent in maintaining German nationalism and what we call Aryan supremacy. And those forces undermined the constitution by shoring up politics above the legal order. Now, undermining that constitution in that manner led to Adolf Hitler and what we call the Third Reich, and eventually leading to the Second World War. What am I saying in short? That if you think that constitutions are just but inconveniences, you will breed social and political discord. You will bring in problems. And therefore, for those ones like Jeff, who need to be inspired to stand in the line to defend the Constitution, read the history of the Weimar Constitution and the onset of the Third Reich under Adolf Hitler and the catastrophe it brought onto Germany. Germans are still trying to get rid of that bad tag. That's to Jeff. The execution, somebody asked, is it your student president who asked the question about the execution? Again, don't despair. The future of this country depends on you. Remember, part of what we have in Article 201 is a principle of termed as equitability. If you, Marion, and your colleagues sit out and say, we are tired of whatever these people are doing, it's not my problem, trust me, you will be saddled with a lot of debt, which you will pay for by way of taxes. That will mean, Marion, for you, that whatever incomes you will get in the future will all go into paying debt and for your daily consumption. You will not have any money to save. You will not be able to invest. Your children will be debt bearers. I'm told that the level or per capita level of debt we have in the country right now, a child who is born in Kenya right now is comparatively disadvantaged because of the debt level that child is carrying. The last time I checked, it was around 8,000 shillings per child. That child breathes his first breath being brought into the world, cries, already there's a heavy debt of around 8,000 on you. So that is the reason why you should be more interested in ensuring that we hold those in power accountable. Do not despair. Stop these things, and we can hold them accountable here and hold them accountable outside. There's a case, I forget the name. Perhaps my good friend Diana Gishengo will remember the name. There's a case that was taken to court on behalf of the Republic of Mozambique, whereby they sued some of their functionaries there for getting them into debt that was found to be odious. I wanted to look at the doctrine of odious debt, because that is a new area in terms of convergence between constitutional law, human rights law, and international law. The doctrine of odious debt, ODIOUS. Those of you who will be writing their dissertations, look at that area. How can we save the Republic by questioning this debt crisis in the parameters of constitutional law, international law, and certainly through the emergent litigations around odious debt? I think I've answered the questions that were posed.
I
Unless
believe
it's
so.
something. Okay.
I believe you have. Now I'd like to invite Ms. Gikonya to respond to the question directed to her. Before that, I want to read a comment by Kipkoril Caleb, who says that I think this was in reference to Mr. Ogada's presentation. Caleb said that the opening statements makes him want to switch off all his devices and listen. Sadala, I wonder what you're doing if not listening. But nonetheless, Ms. Gikonya, welcome.
Thank you so much. And yes, Sylvia, Sadala, and the Madam President of Kabarak University asked a similar question, because they are touching on the issue of contempt. They are touching on the issue of the political culture. And in terms of contempt of court, I really can't speak. I'm not a lawyer. I can't really say I've looked at all at the legal provisions for enforcement around contempt of court. But what, it just reinforces the gap that we have around Parliament, because Parliament has within its means, through the standing orders and through the Committee on Implementation, to enforce court rulings. So the way this is supposed to work is the court will give its ruling directed at a particular minister or a CS or whoever, and Parliament is then supposed to track the implementation of those orders. It has the means of withholding funds, for instance, to a particular ministry, if it feels that there's been imprudent use. It has the means to summon a minister, not for the kind of public display that we normally see, because we understand sometimes when CSs are summoned to Parliament, the real behind the scenes agenda is the exchange of brown envelopes. So questions are asked, but they are being asked so that the CS can do the needful in terms of quelling an issue. So you'll see some committee sessions, but the outcome and enforcement of those parliamentary committee sessions are really don't take place. So yes, it's a concern. Our system is very deeply undermined, because when we went through the constitution making process and the adoption of the constitution, we then charged the implementation of that constitution to the very political leaders whose bad behavior we were trying to fix. And there is a recognition that we need to deal with the political culture, because we need good jurisprudence. We need to keep using the courts and defining areas of law that are not clear, areas of law that we are learning about. But if we keep having an implementation deficit, it's very self-defeating and it reinforces bad behavior. So really, we are saying, yes, we have a debt problem because of imprudent expenditure and corruption. So really, debt per se is not the problem. It's a political problem manifest in profligate spending. And we are seeing here that government can borrow money without feasibility studies, can then proceed to procure that amount of money. And the Auditor General report said that there was 6 billion lost in commitment fees alone. This means that loans were taken that the government cannot even spend because of it hasn't got the administrative requirements in place. Either the land was not procured or, for whatever reason, they are not ready to spend. Then you ask, how do you go do a whole negotiation without having the feasibility, the implementation, the management structures in place? And if we're losing 6 billion in 1 year in terms of penalties on commitment fees, then why are we borrowing in the first place? So my answer really, and I think Diana and Ogada may speak more to the issue of contempt of court from a legal point of view. I'm speaking more at a political point of view. So yes, and Adala is right. Now that the president has managed to secure a political arrangements with the so-called opposition, because it's really not an opposition. If the first moment, at the first opportunity, they jump into government, the president is now confident to continue business as usual. And as we've said, we have had imprudent management of resources being directed into projects that do not give returns in terms of return on investment, in terms of putting money where it's needed, in terms of accountability. And this then only exacerbates the problem. So the solution, there's another gap. We are having debt procurements in a private arena, because now you're talking about commercial debt, you're talking about syndicated loans, you're dealing with the private sector. Some of these are PPPs, for instance. Now, the accountability provisions on government are much more stringent than the accountability provisions on private sector when it comes to public sector reports. And Migai Akech, Professor Migai Akech has written a lot on privatization, and he talks about this lacuna in terms of enforcement of human rights and social economic rights vis-a-vis the private sector. So there's a lacuna in law that needs to be dealt with. But underpinning this really is a political problem that needs a political solution. And that is why those on this call, a number of whom are youth and youth leaders, and I echo what Ogada says, Mr. Ogada says, have to be encouraged that we have just begun the struggle to really liberate our country. And Gen Z has buoyed and given new hope to people, to a lot of people who are feeling very helpless. But this battle will be fought on the legal front, will be fought in terms of organizing as citizens, will be fought in terms of demanding accountability from these very tone deaf, they're being called tone deaf, really, these high impunity leaders. So the battle needs to be fought on all fronts, auditing the debts as we are seeing with Morara and other colleagues who are going out to say, so where is this money? Because these political actions matter. There's also, and I am sure Diana can speak to that, there are actors who are, their proposals to use international courts to hold those international lenders accountable. The last thing I'll say is on the accounting officer. During the crafting of we call them the devolution laws, the 5 devolution laws crafted to implement the Constitution. Because upon the passage of the Constitution, a task force, a proper task force, not this attempt at putting a debt audit task force to do the job of the Auditor General, which is unconstitutional and unnecessary, because really the Auditor General has been unable to audit debt because Parliament hasn't given the money and the information has not been availed. But that said, if they did have the money and the contracts were availed, the necessary information was given, they could audit the debt. So the task force was merely a ruse and a distraction. But during the formation of the task force on implementation of devolution, they then generated the 5 laws, the County Government Act, there was the PFM Act, there was a Transition Act, Intergovernmental Act, and the Urban Areas Act. So the PFM, during the formulation, as civil society actors, we were very keen to ensure that the accounting officer role is made very accountable and strengthened, because once policy is enacted, the person responsible becomes the CS or the accounting officer, however they are designated, who has the authority to incur expenditure and needs to report and to account. So if you look at the Public Finance Management Act, there are disciplinary, Section 74 provides for disciplinary measures against public and accounting officers. So there are provisions in law. part of the problem with non-enforcement is, and maybe this is an opportunity for us. I think Wakili is on the call. It's an opportunity for us to take one provision and test the extent to which we can enforce accountability based on the PFM for a CS who has procured a debt and done so illegally and unconstitutionally. But part of the other challenge in enforcing public officer accountability, because again, there are court cases on that, is there's a myriad of laws, some of which overlap. But the largest impediment is political will. And maybe I can end by saying, apart from political will, there's the social culture that has kind of become acculturated around poor governance. So that I don't mind if my brother or my uncle or my relative works in a public office and really lives beyond the visible means and is bringing home the goodies. We have become accustomed to mtuwetu, and we have not taken the issue of accountability. We haven't really internalized it. So the quest we are on, and why I think I'll keep going back to the Gen Z protests, why they were so invigorating, is because the demand was very clear. The Gen Z said, we want accountability now. We are not trying to cajole or pamper anybody. We want accountability now. And that accountability means that we must also be accountable. So this quest is to do the legal, to do the jurisprudence, to work socially as well, and to do the political engagement in terms of looking for leaders of accountability. So this is a holistic engagement. Sorry for going on a bit long. Thank you.
Thank you so much, Ms. Gikonyo. For someone who is not a lawyer, you sure know a lot about the law. You sure you don't want to change professions, just join the other side. You already have a foundation. But thank you
for that. But we already have very competent lawyers. Let me stay in the social political space.
We can have more. We can have more. And in case you ever decide to, we have a beautiful law school here. You're most welcome. Thank you for that. Meanwhile, I see Onesmus Musungu has a hand up. Onesmus, I believe you can speak now. Welcome.
Thank you so much. I hope the members can hear me.
Yes, we can.
Yeah, thank you so much for the presentation. It was an insightful one. And I can attest to the fact that I have really enjoyed. Hands up to our moderator. Thank you so much for your work. So my question is, and any panelist can answer, please. To what degree does domestic laws, that is our laws, that is the constitution, the statutes, align with the international standards for transparency and accountability? I understand this matter, it has been filed to the court, but my question is, to what degree does our domestic law align to the international standards of, that is, accountability and transparency? Because I understand this public debt is probably a state borrowing, or a state and a private entity borrowing. I don't know who will be able to take that particular question. Any panelists can answer it. Thank you.
Marion, you're muted.
Sorry about that. I've been speaking to myself. Oh God, sorry. Thank you for that. Thank you, Onesmus, for your question. Thank you so much. I believe either Mr. Ogada, Ms. Gishango, or both of them can respond to you. We also have Grace Kimone. Your hand is up, and I believe you can speak now. Welcome.
Okay, Sorry for the slight confusion. I had a problem with my device. It's Young Green.
Oh,
So,
okay.
so my question is on the issue of odious debts. So there's been a great argument on the X space of whether the concept of odious debts applies to Kenya. So that will be the first limb of the question. Then to extend the question, if you speak about the concept of odious debts in the international sphere, from my little reading about that, it's more of a doctrinal theory than it is an established principle of international law. So my question is, if you approach the court and you claim that the debt that has been taken by the government is odious, what can you rely on when addressing the court? Then the second question, if our domestic courts proceed and make a determination that the debt was odious, the debt has already been taken, how can the lenders be able to hold the government, let's say a regime that has exited, accountable on still the same aspect of odious debts and say that we gave them this, it was this way and this way? Yeah, thank you.
Thank you so much, Young Green Peter Modei. I believe Mr. Ogada can answer your question now that he's the one who spoke about odious debt. And something tells me you're just doing research for your coming dissertation, now that it was suggested. So you may need to meet Mr. Ogada kando ya tent. But yeah, thank you for that. I'll invite the panelists to respond. Up first, Ms. Gishango, I believe you're ready. Welcome, you can respond to.
Thanks, Marion. And I know there's the first question of how aligned Kenyan law is to international standards of transparency and accountability. And there was an earlier question around how much maybe what we have said feels like an academic exercise. But just to let me start with whether this is an academic exercise and what happens around enforceability. Oftentimes we use strategic public interest litigation or strategic litigation. It's a placeholder. It's a placeholder for the norms we set ourselves to. They may not be immediately enforceable, but they trigger very, very critical processes. So they are not always an academic exercise. And the litigation that is going on around the debt contracts to be availed and so on is not the only thing that is happening to ensure that we enhance the transparency and accountability standards of our public debt, contracting, management, utilization, and so on. When this matter was first filed and reported on, remember, everybody, including the opposition, spoke to this particular process. As a result of all the questions that were raised and to ensure that they deal with people who would raise grievances, there was a lot of compensation of people who were to be affected by the SGR, just to reduce the amount of noise that would arise out of it. So that was already a benefit. And think about what happened in the 2022. Again, political play, but there is a chance that one day we will get leaders who are worth of our constitution. This government committed that the first thing they'll do is table the true SGR contract. That didn't happen. But increasingly, as people negotiate, or whenever we hear that we are about to get into another huge infrastructure contract, the questions that Kenyans raise, some members of parliament, we keep raising the bar. The secrecy, the acrobatics that are done tend to increasingly reduce. Now, And I want to link this to the earlier question of the issue of conflict of interest between confidentiality and sovereignty. When it comes to public debt, please also read about what happens when a country defaults on sovereign debt. So these are countries like Zambia, Ghana, Argentina has been there, Greece, and so on. As part of the debt restructuring is that all creditors, all persons who are owed anything by that particular country must fully disclose what they are owed, so that then the plan of restructuring is able to cover everything, all the terms, the condition, if it is a resource-based agreement, and so on. So that then would also speak to the likely interpretation of that particular conflict. Because when you're in default, then we cannot have a negotiation with you when there is still confidentiality. Everything must be laid to the table. So if we are to move to the best practices based on even trade and banking agreements, then openness and transparency becomes a huge part of it. Now, when Council Ogada was starting, he cited several articles. The good thing about the Constitution of Kenya is transparency and accountability is not anything Gen Z have created. They have just read and decided we will reiterate this particular thing called transparency and accountability. What is required, especially in our Article 10 and our Chapter 12 of the Constitution, and even in running parliamentary and executive business, the principles we have set out for ourselves when it comes to public finance do measure up to international principles for the Kenyan people, and conversely for any lenders who would want to come to meet those particular thresholds. The thing about debt is, and the politics of debt is, why we all must give political attention to debt is debt contracts favor the lender. So at any given point, rarely do lenders lose. Even for you as students, when you're being told where to invest, we are told to invest in treasury bills, treasury bonds. It can never go wrong. The government must always pay. So most of debt contracts are drafted in favor of the lender. But increasingly, since the discussions around when we continue to study the impact of poor borrowing or bad. I was in a conference where Kenyans, including Ogada, said it's just bad manners that has put us where we are. Oh, and I think Shiro came and added to that particular language. When all these bad manners around debt is because our political class knows you have to pay sovereign debt no matter what. But the discussion on odious debt, which was often linked, you can never look at odious debt from just a technical point of view. It is political because the regime that is in power makes very, very calculated decisions and steps to compromise all mechanisms. So, for instance, there's a case on South Sudan around odious debt where the current president has just ordered one of his ministers to contract a debt for oil as the security with Dubai. Dubai is Qatar, the name of the state. But that debt is to be repaid by the people. So when dictators or leaders who just, even in a democracy, go against the law, who are they borrowing for? Is that sovereign debt anymore? So whereas it's still a doctrine, its enforceability then would lie in the local laws. And in the case of Kenya, an odious debt one is, how was it procured? Was it already authorized? Did it hit our consolidated account at the central bank? After that, was it utilized for what Parliament approved? And did what Parliament approved, was it according to our Public Finance Management Act and our Constitution? If we interrogate all that, then we will begin the journey of interpreting what is odious debt. But odious debt, in most cases, it is around the political regime. So we must approach it from a very, very political angle. How to drive this accountability, therefore, has to be through all forms of mechanisms. And I foresee a place where, seeing what the controller of budget has been sharing lately, I think she shared that the cost of borrowing is extremely high for bilaterals and for multilaterals, including the World Bank, that what we pay as service charge and so on, and that has raised the scrutiny for our multilateral international financial institution that are supposed to give us credit on very, very good terms. The Auditor General is now increasingly, as a result of, I would say, more public pressure, moving into giving us what is the status of our debt, how is debt being utilized, how is it being procured. So in that particular sense, it is not a very academic exercise. And for where we are as a country, find out what has happened happened a long time in Benin or Burkina Faso, what has happened severally in Argentina that has just had a whole cycle of debt default and debt restructuring anchored on the rule of law, what has happened to their leaders. Mozambique, where the finance minister is currently serving a 12-year jail term. The debt was declared unenforceable. Some of the creditors have used other mechanisms to try and recover, but one of the debt won't be repaid at all. The lenders have to look for alternative ways, go after the person who therefore signed for that contract. So it moved to personal responsibility. If we get to a place where we do a performance and forensic audit of our debt, I know for sure we stand a very high chance of having debt declared odious. And this can be done both by a process of the judiciary, a tribunal, or even within Parliament. There are different models that have been used across the world. In Kenya, I know a number of us are already getting ready to declare some debt contracts that we have been auditing over time odious. Why is this important? Even the minute we file that particular litigation, what happens within government is the technocrats begin to remind the politicians that, look, these are the consequences that are likely to befall us. And when there's that non-cooperation, the bullishness of the political class weighs down, and finally, the rule of law that anchors the required transparency and accountability kicks in. So please, let's not tire. So many things have changed in the last 2-3 months, and within the last 24 months, where there has been a lot of litigation around budget, expenditure, revenue, and debt processes in this country.
Thank you, Ms. Gishengo, for that. That was pretty.
And sorry, Marion, I shared the citation for the Mozambique case that is popularly known as the Tuna Bond case. It is the Republic of Mozambique versus Credit Suisse International and others. You can share it with everybody, and I'm happy to share a link. Yeah, it's a very interesting litigation, and I hope at some point we can also bring the team that led this particular litigation to inspire our thinking, and for those who will join Evans in constitutional litigation, our drafting.
Thank you. Thank you for that. We have shared it on the chat to everyone, so I believe everyone can see the case citation. Thank you for that. Before I invite Mr. Ogada to speak, I see there's a hand by Gregory Maina. This will be the last question before we close the Q&A session. So Gregory Maina, I believe you can speak now. Go ahead, ask your question. Gregory, are you able to unmute?
Thank you, Marion. Can you hear me from your end?
Yes. Yes.
Okay, thank you so much, Marion. I'm Gregory Kamau, and I want to thank the discussants for the topic that we're having today on accountability and the debt contract and crisis in Kenya. Mine is a comment and on the reasons as to why I think we are in this all of the debt crisis. First, I believe it's on the issue of budgeted corruption. And on this, I believe in the current regime that we have, where we are led by the president, who has his men and women, we call them the president's men. And by doing this, they ensure that they put these people in positions of power so that they can loot these monies. And by looting the monies, you know, they understand by being the president's men and the women there, you know, they get, and having the proximity to power, they understand that they are well protected. So that is one reason as to why we are in this problem. First is budgeted corruption. And with this, we can look at the traits and characters of the people around the president. We can tell them these are the people who are thieves. These are people who are corrupt. These are people who are cabinet secretaries, MPs. We can see them. Some even have sexual offenses cases in court. These are the people who are near the president. And so I believe, first of all, this is the bigger problem. And the problem starts from the top. If we have a corrupt system from the top, the system trickles down to the last point. Secondly, we have the issue of tokenism. And on this, we believe that the president has mastered the art of tokenism. And the art of tokenism, where they believe people are given offices. We have seen in several instances where even non-qualified people, mistresses, wives, they are given these offices. Does not mean they are the most qualified people in those offices. And this is an issue. This is a very big issue. And to also state on that, well, I remember Honorable Emilio Tiambo once said that it is the good girls don't get the corner office, which I agree. But we also have to say that some of these girls are not, or these women, girls are not bodies enough to say that they deserve this office. With this regard, I have to say that yesterday I was reading a story with regards to promotions that are happening in the police services. The promotions are happening to people we can see from the senior officers, their wives, their mistress. That is what is happening in the police offices. And this thing is an issue to this republic and this country. Thirdly, we have the issue of bribery, where if in case the president notices that in case the president notices that one is influential, we can see what the president is doing. try to bribe them. That is what the president is doing. And we can see this from what Morara was, the revolution that is happening currently from people like Morara. We can see the other day claimed that the president and the people around them, they are trying to bribe them, but they refused. So bribery is also an issue that is being used, and is a tactic which is being used in this country to make sure that people are silenced. And also another thing, on the issue of tokenism, we say that people are given promised offices, promised goodies. People are being promised goodies in these offices. People are being promised gifts. People are being promised everything, which is a lie, and definitely is to hide the corrupt system that is happening in this country. The problem is that these people are not aware that the citizenry is woke and sober, and they won't allow this to happen. It won't happen in this country. And by this, we need to understand that there's an absolute disconnect between the government administration and the citizenry. We need to understand that we can see the way they are curtailing. Even the other day, there is an MP who proposed a bill, the demonstration bill, to curtail Article 37 of the Constitution on assembly and demonstration by the people. So basically what this is happening, these are the problems that this country is having, and they're the reasons as to why we have the deaths that we have. Since people are just having a budgeted corruption, and it's a system that must be abolished. Second, fourthly is we need to tell each other the truth that we are not the new Singapore. We are not the new Singapore. Kenya, we are much more far-fetched with PR stunts, where we believe that they are the way to go forward, and that is not the way to go forward. On the issue of accountability, we can learn that there is an issue with leadership. The leadership is not accountable to anything. Yesterday on X, there's a lady called Hanifa, and she did a fundraiser for the victims of the demonstrations 2 weeks ago, and she raised above over 30 million shillings. And yesterday she released the audit reports of those, the audit reports of how the money was used from A to Z. What basically these leaders don't want to do in this country, they don't want to be told the truth, and they don't want to be told, they want to be accountable for anything. So lastly, I'll say that these leaders have promised us the land of Canaan, and it is good to say that we are never near Canaan. We are never near Canaan. It is only them who are in Canaan enjoying milk and honey. And these are the reasons as to why we as a country will not continue to grow and develop unless these leaders are let.
Gregory, thank you. Sorry to interrupt you. We're running out of time. So thank you for your contribution. Thank you so much. We appreciate your comments, and we have taken note of them. I'd now like to invite Mr. Ogada to respond to the questions directed to him. Then we can summarize. Mr. Ogada, welcome.
Well, I think we have about 4 issues that remain outstanding. Let's start with the issue of contempt of court. Contempt is worrying. Even at this hour, we are facing continued contempt by the acting Inspector General of Police. He has been ordered to come to court several times. He has refused to show up. For those of you who are, again, students of constitutional law, I want you to read this case. It's a case from the Supreme Court of Canada, United Nurses of Alberta versus Alberta Attorney General. This is a 1992 case, United Nurses of Alberta versus AG Alberta. And this is what Lord Justice McLachlan said in that case, that criminal contempt is not merely a matter between the parties involved. It is an affront to the authority of the court itself, requiring a response that serves to uphold the rule of law. So you, as future court officers, if there's one thing that should anger you and inspire you to action, is the culture of contempt of court. So it is something that we will need to deal with. And it goes on to the second question, the possibility of holding people to account. Again, as future practitioners of constitutional law, we have several ways, what we call polysemous nature of constitutional order. And again, Marion, I had you send people my way, people who want to read. They will have enough to read. We have Professor Shaw and Jacobson. They have the Oxford Handbook of Comparative Constitutional Theory. That is a book you guys can get and read. Now, when you read Shaw and Jacobson, they talk of what we call the juridic and the civic aspects of constitutionalism. The juridic constitutionalism, this is what we defend in court. We are defending constitutionalism in court. Then we have the civic aspect that should be preserved and protected by the citizens, certainly by politicians, what we otherwise call constitutional conventions. That will be for us to discover as future constitutional practitioners how we actualize, how we protect constitutionalism in the civic context. So let us think of how we'll do that in future. And part of getting the citizen involved, particularly in the civic, in the debt space, let's think of public participation. And public participation, there's ongoing litigation concerning public participation in court. Public participation is not tokenism. It's not a favor. And we have three elements that must be broadly incorporated in public participation. We have what we call consultation, which is a two-way relationship between the citizen and the governors. Then we have access to information, what we are currently seeking in court through this petition. Then we have what we call active participation. After you've received your information, after you have consulted, what input do you as a citizen bring on the table? So read on those. We have an OECD, the OECD. The OECD has a lot of material on public participation online. Please read those. We don't have time to go through them. Look at what the OECD and the International Association on Public Participation. It's a whole website. Read online, see what is demanded. Those are assignments that I will follow up with Professor Ambani to see if you guys are giving him material. Now, domestic law, do they align to international standards? What domestic law does, to the person who posed the question, the Constitution specifically, it delineates broad principles. So for you as future judges, you are supposed to distill these principles and give them some teeth. So for example, when you talk of international law, we have what we call soft law principles. And soft law principles have their contributions to the development and to human rights. Please look at that. I think it's the same person who asked the question of whether odious debt applies to Kenya. I want you to read the interconnectivity between public international law and odious debt. There's Professor Robert Hauser. I'll write the name on the chat function. Robert Hauser has written a document for the United Nations Conference on Trade and Development. You read the document by Hauser, Professor, and see how he tries to make a pitch between the interconnectivity of public international law and the doctrine of odious debt. Certainly, it would apply if you, as lawyers, if you, as researchers, think of how to connect the various multifaceted phases of international law to domestic law. It certainly will apply. What else did I leave pending? I think more or less we have handled everything that was thrown our way. Thank you very much.
Thank you very much, Mr. Ogada. I believe you have. And to just cherry on top is you have said we are future judges, and I will take that home. Thank you for that. We have now come to the end of the Q&A session. We'd now like to conclude by hearing the concluding statements from our panelists. So in a minute, at most 2, I'll invite our dear panelists to give their concluding statements. I'd begin with Ms. Wanjiru Gikonyo. Ms. Gikonyo, I hope you're ready.
Yes. Thank you so much, first of all, Marion, and to the entire Kabarak University and Avid Readers team for this opportunity to share my reflections and more so hear the very informative insights of my colleagues on the call. This has been very enlightening. And I'll speak maybe to, again, like I said, the socio-political context, and just reiterating why we must not tire. We have won many gains. We were able to, as Kenyans, we have a history of activism from before from the as soon as the colonialists landed on our soil, we've had various forms of activism. And this activism has helped us in many ways and made us really a very significant actor on the regional stage. Kenya is not necessarily endowed with many natural resources. They are now being found, and some are not are being legally appropriated. But our greatest resource is the people. And we boast one of the most progressive, constitutional, democratic dispensations in the region because of this spirit of activism. So we must not tire, and we must continue to file every case and take the needed action at every point in line with what we are able. Again, as Diana said, Okwa Uchumi and TISA put up a panel, and I was on a panel with Okio Mtata, who is our public interest litigant par excellence, and now, of course, is a senator. And he said his call was, do what you can with what you have, but make sure you do something. So you take a short look at the problem and a wider look at the solution. So whereas I agree with Maina that, I think it was Maina, things are very bleak, don't take a long look at what's not working. You have to look at a long look at the solution. Otherwise, you'll get discouraged. And remember to do what you can with what you have, but make sure you do something, and every little bit works. And maybe the last point is to say to Diana and the Okwa Uchumi team, as you deal with this odious debt issue and prepare some well-informed evidence-based cases and consider the mechanism of accountability alongside the legal, please institute a social, because accountability is a two-edged sword. It has to do with our political leaders. It also has to do with our citizens. And widespread citizen action on the issue of odious debt will allow a conversation with citizens about political accountability, the need to hold leaders accountable, the need to vote in good leaders. So I think maybe my very, very final point, where I disagree with the earlier speaker, the biggest disconnect is not between government and the citizenry. The biggest disconnect is between the intellectuals, like those who are here, civil society, and the citizenry. The values we espouse and really value, we are not doing enough, or we are not taking the needed actions. We are not organizing. We are not engaging adequately to carry the citizen with us. So that is the divide that we need to bridge. So thank you, and a good afternoon to all.
A good afternoon to you too. Thank you so much for your concluding statement. I'd now like to invite Ms. Gichengo to give her concluding statement in a minute or two. Ms. Gichengo. Okay, Ms. Gichengo may be experiencing challenges. So I'd invite you, Mr. Ogada, to give us your concluding statement.
Ms. Gishengo is here.
Oh, you're back. Welcome.
I'm
And
here.
yes,
I am here. Maybe my speed is not very Gen Z of unmuting my mic, but I'm here. I think in closing is just to first thank you, the Kabarak Law School, for you've had a series of discussion around our public finance processes and debt. This is to urge you to continue to do that so that we prepare ourselves for the time when we will be at that the only way of managing that the concept of fiscal constitutionalism will be something that is considered a norm, a value that is really deeply valued by our institutions, particularly Treasury, Parliament, as well as the horizontal oversight institutions that we have in this country. In closing, I currently at TISA, we are hoping that we can have as many people like Morara Kebaso pushing for social accountability on different fronts. And I just want to highlight a few opportunities that will be available to us in addition to all the other spaces of accountability within, say, Parliament when we are doing memoranda, litigating, and so on. One, based on the Gen Z protests, Gen Z-led protests, the World Bank and the IMF have really, I don't know, I would say they are finally listening, and they now know that there is a greater need to engage the public whenever they are engaging in the frameworks for their multilateral lending. Based on where we are, our president is in China, definitely on a borrowing mission or a pilgrimage together with the entire African family. We need to keep up the pressure, but the space for bilateral lending, state to state, and that of, say, even commercial loans will go up, bonds and so on significantly. So we are likely to resort to the World Bank and the IMF. Now, when that window opens, can as many of us give views as possible? And I think I'll be in touch with you, Marion, to ensure that I am able to share whenever this particular window opens. Unfortunately, that is very short term because the IMF and the World Bank, whereas their contracts are, say, transparent, their model of funding and the conditionalities of the prior actions are not supportive of developing economy. They just extract, and extract. So there'll be need for reforms at a different place. The CS Treasury has just started a process of what they're calling accrual accounting and a task force to roll out that particular process. It's largely within government. It just means for every money that comes in, there is a concurrent process that shows how it went out. So this will become a space for us to easily conduct and trace transactions more easily. As practitioners of law, as people do the social accountability, is to quickly think about how we can quickly support the emerging movement in stating, was that particular transaction legal or within the frameworks of the Public Finance Management Act. This year, or based on our budget, we are going to repay 1.895 trillion as public debt servicing. We will borrow currently about 800 billion before we do supplementary budget. So already what we must repay is higher than what has been approved for borrowing. If that doesn't tell you something, at any given point, if what you're repaying and you're still borrowing is higher, it means we are not in a debt trap. We are already in preeminent debt default. As this happened, the pressure on your elected representative whom you have delegated power. That duty right now for yourselves as the generation that must repay these loans. Most of us won't repay them as much as you will. That particular duty of vigilance and speaking out in your own ways, including articles, your moot courts, and so on, is more needed than ever. Because, like I stated when I was starting, where we are right now, we run the risk, and most of you have also indicated around salaries. We run the risk of having a government that cannot serve any of our needs, yet it continues to tax us. So we already resource it to deliver for us. So we are the biggest shareholders in demanding accountability from the company that is Kenya. Thank you.
Thank you so much, Ms. Gishango, for your concluding statement. Mr. Ogada?
This past week, we lost a preeminent constitutional scholar, Professor Frederick Schauer from the University of Michigan in the United States. Professor Schauer goes down in memory with a quote attributed to him to the effect that government today is synonymous with open governance. Open government is synonymous with governance. I had spoken about the distinction between government and governance before. I'll not go back to it. Read about it in your own time. Open government and governance is important for us because they buttress the rule of law and constitutionalism. The rule of law and constitutionalism are the bedrock of a just and stable society. Together, they ensure that governance is conducted within a framework of law, limiting the exercise of power, protecting individual rights, and upholding democratic values. While constitutionalism provides the structure and guiding principles for governance, the rule of law ensures that these principles are respected and applied to all equally, without exception. Upholding the rule of law and constitutionalism is crucial for fostering public trust, promoting accountability, and safeguarding the freedoms necessary for a vibrant and resilient democracy. The challenge to you as Kenya's future generation is for you to uphold the rule of law, to uphold constitutionalism, even in the face of the challenges we face today, because a continued commitment to these ideals is essential for the protection of human dignity and advancing the societal progress of the community called Kenya. Thank you.
Thank you so much, and may Professor Shaw rest in eternal peace. Thank you so much, panelists, for your time. Thank you so much to our audience for joining us today. I'd like to read out Mr. Elisha Ongoya's comment. He says, this is a very enriching conversation on a very relevant and timely topic. Thank you, panelists. Thank you, members of the audience. Reform starts with an informed citizenry. You are the informed citizenry. The greatness of this country depends on you. Keep pushing with the insights from this platform. Mbele iko sawa. Thank you so much, Ms. Longoya, for that. We cannot thank you enough for making the time to join us today. This is the last of a series of webinars that we had in partnership with Ms. Wanjiru Gikonyo on the topic of fiscal accountability in Kenya, basically public funds accountability in Kenya. So we are eternally grateful to you, Ms. Gikonyo, for this idea. This has been your brainchild. We have had the honor of having 3 sessions, and it's been informative. It's been very, very informative, and we are forever grateful for the partnership. We also are grateful to everyone who's taken part in making this forum a success, in everyone who's taken part, played one role or another, setting up the the webinars, setting up the links, setting up the posters, publicizing, and everyone who joined. Thank you to the Kabarak Law Students Association for the great partnership. Thank you, because you have given us all your support, and your president was here today, and the students, you've joined us today. Thank you so much. Thank you so much, Mr. Gekombe, who's been coordinating all the way from the south of Africa. Thank you to Mr. Soita Shitanda. Thank you, Ms. Sylvia Nyanchama. Thank you, Carol Anthony, and everybody. Thank you very much for joining us. We will have more sessions coming up. We have 3 more sessions coming up this month. We hope you will be there with us. We look forward to having you as we celebrate 5 years of the Avid Readers Forum. By the way, today is our birthday. The forum began on 5th September 2019. So we turned 5 today. Congratulations to you for making this a possibility for the last 5 years. And we hope for more than 5 more. And in celebration, we'll be having a series of webinars every week, starting next week on Wednesday. Watch out for the Kabarak Law School pages. We'll be making our announcements there. For now, we are eternally grateful, and we cannot say thank you enough. Thank you, Mr. Ogada. Thank you, Ms. Gishango. Thank you again, Ms. Gikonyo. For now, have a good evening, afternoon, wherever you are following us from, and let's keep in contact. Let's keep reading, and let's keep making this country a better place. Mbele iko sawa. Kwaheri.